Hey guys, good morning, Sunday morning. The question is, what do Darrell Brooks and Ted Bundy have in common? And I mean, not just being scumbags, something different. The answer, they both represented themselves in court. What's Charles Manson got to do with it? He wanted to be in that club too. He'll factor into the story here in just a moment. So yeah, Ted Bundy, known as somebody who potentially had a screw loose, he represented himself in court as well. I thought that was an interesting fact. I've seen some people talk about Judge Dorow. Wow, she shouldn't have allowed Brooks to represent himself or let him represent himself. And that's opened this case up to potential appeal. Well, the fact is he has a constitutional right to represent himself. And if you deny it improperly, then that will result in a successful appeal and just get thrown out. So let's look at the law on that. We'll look at the Supreme Court case that sets the law for all the land, how Wisconsin interprets that and handles it in their state, and then a situation where the federal court stepped in and curb stomped the Wisconsin courts because they denied a guy his right to self-represent. The federal courts threw out the conviction and said, you cannot do that. You need to let the guy self-represent. So it's a big deal. And you could bet, of course, Judge Dorow knows all of this law and knew it all in much greater detail than I do before she ever ruled on any of this, right? She just didn't step up to the bench and do things on a whim. So anyway, let's start off with the Supreme Court. So there was a guy named Ferrata who was being tried for grand theft, and he informed the court before the trial started, I want to represent myself. I think the public defender's overloaded. I know my case better than anyone else. I want to do it myself. And so the judge said, well, I think that's a bad idea. You know, you should have a lawyer. This is a technical proceeding. The judge asked him what his background was. The guy had, I think, a high school education, so he could read and write. The judge said, well, tell me about hearsay rule. How does that work? The guy tried to do that. The judge said, tell me how it works when you impanel jurors. How do you strike jurors? The guy tried to do that. And the judge said, you know what? This is not a good idea. I'm not going to let you do it. And so he had a lawyer, and he was convicted. And it went up to the United States Supreme Court, and they threw out the conviction and said, look, this guy has a constitutional right to defend himself. And some of the quotes out of that case, I think, help show how this works and overall before we take it all the way back down to Waukesha County. So the court said the question is whether a state may constitutionally hail a person into its criminal court and there force a lawyer upon him, even when he insists that he wants to conduct his own defense. It's not an easy question because we know people are sometimes terrible at it. Added that part. But the court said, but we have concluded that a state may not constitutionally do so. The court said that the right to self-representation, to make one's own defense personally, is necessarily implied by the structure of the Sixth Amendment. The right to defend is given directly to the accused, for it is he who suffers the consequences if the defense fails. And it is an interesting notion. Well, I can see on one hand, you have to make the person have a lawyer, but on the other hand, you're making the person have a lawyer. Quote, it is undeniable that in most criminal prosecutions, defendants could be better defended with counsel's guidance than their own unskilled efforts. But where the defendant will not voluntarily accept representation by counsel, the potential advantage of a lawyer's training and experience can be realized, if at all, only imperfectly. To force a lawyer on a defendant can only lead him to believe that the law contrives against him. Moreover, it is not inconceivable that in some rare instances, the defendant might present his case more effectively conducting his own defense. Personal liberties are not rooted in the law of averages. The right to defend is personal. The defendant, and not his lawyer or the state, will bear the consequences of a conviction. It is the defendant, therefore, who must be free personally to decide in his particular case whether counsel is to his advantage. And although he may conduct his own defense ultimately to his own detriment, like Brooks, his choice must be honored out of that respect for the individual, which is the lifeblood of the law, that last part quoting a little case called Illinois versus Allen. The court also said, although a defendant need not have the skill and experience of a lawyer in order to competently, intelligently choose self-representation, he should be made aware of the dangers and disadvantages of it, and warn him about it, so that the record will establish that he knows what he's doing and his choice is made with his eyes open. Now, in terms of whether somebody has to pass a bar exam or you get to ask them all these questions about technical things, the court said this: we need make no assessment of how well or poorly Ferrata had mastered the intricacies of the hearsay rule and the California code provisions that govern challenges of potential jurors, for his technical legal knowledge was not relevant to an assessment of his knowing exercise of the right to defend himself. So you don't have to know the law as long as you're told, look, there's a lot of law out there and you probably don't know it. You would be better off with a lawyer If you decide to roll your own and do it yourself, that's on you. The court said, enforcing Ferretta under these circumstances to accept against his will a state-appointed public defender, the California courts deprived him of his constitutional right to conduct his own defense. Accordingly, the judgment is vacated. So that set the law of the land in 1975 for every state, every defendant everywhere, that you not only have a right to counsel, but you have a right to not have counsel. Now, nothing's ever exactly clear under the law, so we'll look at how Wisconsin implemented that, and when they went too far, still not letting someone represent themselves, even out of Waukesha County, the federal court stepped in and said, no, it's a constitutional right. We'll throw verdicts out if you don't let people represent themselves as long as they meet the criteria. Now let's come back to our good friend, stable genius, Charles Manson. He wanted to self-represent himself in his trial, and eventually the court said no. So he appealed, and during the appeal, this Ferretta case comes down, and Manson says, look, I have a constitutional right to defend myself, and they didn't let me do it, so throw that out. The court said, yes, you're totally correct. However, that decision came after your conviction, and we're not going to apply it retroactively, and your lawyer did an okay job, so you get to just stay in jail for that reason. So he almost made the club of self-representing lunatics, but not quite. All right, let's leave the sunny environment of California where that case was decided and bring it on back over to Wisconsin, land of cheese and beer, I think. Who knows? People that live there maybe. And talk about how they handled the law up there. So they do a very practical application, straightforward, and they say, listen, two things have to happen. One, you have to have a knowing, intelligent, voluntary waiver. Okay, that's thing one. That's a constitutional requirement. And second, you have to be competent to represent yourself. And that's been the subject of some debate. So under the knowing and voluntary part, there are four things the court is supposed to do, and the Wisconsin Supreme Court has required the circuit courts, the trial courts, to do this colloquy. In other words, a discussion with the defendant. And you're supposed to make sure that the person is making a deliberate choice to proceed without counsel. Then you make them aware of the difficulties and disadvantages of self-representation. They don't have to go research that themselves. You're supposed to tell them that and make sure they're hearing what you're saying. You don't have to use the word understanding. They have to be aware of the seriousness of the charges, and they have to be aware of the range of penalties. And if you have all these things and no one's coercing the person and that, then you can have a knowing and voluntary and intelligent waiver. Intelligent doesn't mean you set them down for an IQ test. It doesn't have to be in Mensa. The point is, this is somebody who can reason, as Brooks could, and it's explained to them what the consequences are of their decision, and they choose to do it anyway. He clearly did that. The judge had an extensive record establishing that fact. So the second thing is, then you have to be competent to represent yourself. So there's a lot of discussion in the law whether competence to represent oneself is a higher standard than competence to stand trial. And because the decision to not represent yourself is a constitutional right, there was some debate over whether you could have any higher standard at all. But the court finally settled on that and said, yes, you can to some degree. So you can't set up some serious burden to exercise in your constitutional right. But the court did recognize, which I think is practical, that being able to show up and be tried while you have a lawyer, your competence there is not necessarily completely synchronous with being able to represent yourself. And so Wisconsin has laid out like a little checklist of things. So the court can consider physical or psychological disability that significantly affects your ability to communicate a defense. Now that's not the same, I think, as being diagnosed as a bunghole, as basically Brooks was. We're talking about, that you start fluttering off and things like that. You think you're in the underworld fantasy world or whatever. Again, because you're talking about disqualifying somebody's constitutional right if you take this away from them. Their literacy and education. So in other words, can they at least read this evidence rule that you're handing them? If they can't read it, that could be a problem in self-representation, of course. Their fluency in English, because if the trial's in English, they got to be able to talk to the jury. They got to be able to hear the judge, they got to be able to communicate with the judge. So these are the things that you look at, and it doesn't take a lot of education. In fact, the final case we'll look at, the guy had a 10th grade education. But again, you're trying to make sure that can this person at least talk to people in the courtroom and understand the things from a verbal and written standpoint. But you're just trying to see if the person can communicate in court and have a basic ability to look at the documents that you're handing them and read that. It's not on you if they understand fancy legal words or not, because they can go to the law dictionary for that. Again, they're making a choice to do this after being told there's a lot of things you're going to run into you probably never run into before, and they want to do it anyway. and it's their right to do it. Of course, it wouldn't have made a difference in Brooks' case because he's totally guilty, and that's what would have happened with his other lawyers anyway. So that's how Wisconsin sets it out. They say, look, first, you do an inquiry with the defendant and make sure that you got this knowing and voluntary waiver. Second, you test their competence to the slightly higher degree, and then the court issues its ruling. So there was a case called Amani where the court in Waukesha County, it wasn't Judge Dorow, issued a rule that said, I'm not going to let you represent yourself. And the court said, you haven't told me any good reason to do it, and I don't think you really know how bad this could be, and you only got a 10th grade education, and you've never tried cases before. I'm not going to let you do it. Now, the Wisconsin higher court said, well, it's not ideal, but it's really in the trial court's hands, so we're going to sustain the verdict. This guy goes over to federal court on a habeas petition and appeals, saying that my constitutional right to defend myself was taken away from me in violation of my rights, and this verdict should be thrown out. And the district, federal court, and circuit court of appeals agreed with that and said, look, you can't do that. You can't say, well, he doesn't have a good reason, so he can't do it. It's his constitutional right. So the court found three things that they said, Wisconsin, don't do this. The first was, the way that the court put it, it was the defendant having to persuade the judge that the waiver is knowing and voluntary instead of the judge doing an inquiry into it. And that's not the defendant's job to do that. The judge is supposed to make the inquiry for that and answer the questions. The defendant does that. Second, the defendant had to persuade the judge he had a good reason to self-represent. And that is, he can have a terrible reason, which is, I just want to do it myself. Maybe the lawyer would be better, Your Honor. I don't care. I want to do it myself. It's his right to do that. Just like it's your right to plead the Fifth Amendment and not testify. The court can't go, well, I think you probably should, though. Probably be better for your case if you just waived your Fifth Amendment, got up there and told your story. So I'm going to order you to tell your story. You can't do that. That's the defendant's choice. Third, competence standard is too demanding. They said the court basically tried to act like this guy needed to be some experienced criminal defense attorney in order to represent himself. And they said, look, he has a 10th grade education. He told the court he could read at a basic college level. That's good enough. He doesn't have to have tried cases. He could speak English. He knew what was happening around him. He could read pretty well. And so he needed to be able to represent himself. They threw out his conviction. So the moral of the story is, if Judge Dorow had said, look, I think you're a big old butthole and you got some personality disorders and it's a bad idea for you to represent yourself, so I'm going to not allow you or let you to do it, then the case could be thrown out just on that basis that he had his constitutional right denied. So the Seventh Circuit Court of Appeals said self-representation is a Sixth Amendment right and a trial court may not deny its timely exercise by a competent defendant. The court also said, listen, the duty to tell the person that you're at risk if you do this, that's on the court. It's not on the person to go out there and research it. And they say Supreme Court decisions make clear both a trial duty to warn, but also the narrow limits on its power to prevent exercise of the right of self-representation. So Judge Dorow had to deal with this dilemma that if she lets a guy represent himself who's incompetent to do it, she'll get reversed. If she doesn't let him do it, then she could also get reversed. And that is a dilemma. The way you resolve it is you do this exploration on the record, discussing with the defendant these factors that I've laid out. And she did that plainly, multiple times, and very carefully, and very clearly, and very slowly, and very simply. And Brooks obviously wanted to represent himself. I mean, he wanted to make a jury nullification argument. He wanted to do sovereign nonsense. His attorneys weren't going to do that. He wanted to do it. He did it. He lost. One more footnote on the Ted Bundy situation. His lawyers were demoted to standby counsel. And of course, I have seen again people saying, well, the judge should have given Brooks standby counsel. That's what he wanted under the Burger King doctrine. However, he does not have a constitutional right to standby counsel. That's just not how the amendment's interpreted. And Wisconsin has been very clear in its law that a defendant does not have a right to standby counsel. The court can appoint standby counsel in Wisconsin, and sometimes they do, but that is considered for the benefit of the court, not at the request of the defendant, and not due to any right the defendant has. So the judge's decision to not appoint standby counsel was clearly within the law. And not only that, she told Brooks before he fired his other lawyers, if you're doing this thinking you're going to get standby counsel, I am not going to appoint standby counsel. You do not have a right to it. You will not get it in this case. If you let these lawyers go, they're not going to be sitting with you or behind you. They're going to be gone. Do you understand it? He said, and I'm quoting him, yes, that's fine. So hopefully this gives you some insight on the dangers on the flip side of this. If Judge Dorow had refused his right to represent himself, she could easily be reversed for that. And in fact, more likely to be reversed than doing what she did, which is following the court's instructions to have a colloquy, examine the factors, and then if he meets them, allow him to represent himself, even if it's to his own detriment. That's his clear constitutional right. Thanks, bye.